afternoon and welcome to the CAPE webinar for Thursday the 28th of May. Today we're looking at the construction contract obligations with, we have Daniel Tay, Mei Ling and Sam Chu. My name is Jordan and I'm the Regional Services Administrator here at CAPE, and I'll be in the background today just making sure everything goes smoothly. So just a little bit of information about CAPE, just in case there are any non-members listening in today. We are an internationally recognised professional body. Membership of CAPE shows your peers, employers and the public that you're a competent and ethical professional who can be relied upon to strive for the highest possible standards. CAPE members work across the life cycle of the built environment, specialising across a wide range of disciplines. By bringing these disciplines together, CAPE shares knowledge, raises standards and develops professionals, enabling a professional construction sector that works to create better, safer and more sustainable buildings that enhance people's lives. We do like to make our webinars interactive, so we do encourage you to send through any questions. We can go through these at the end with a Q&A session with all of today's speakers. If we get a lot, we might not have time to go through them all, but I will work with everyone to put together a question and answer flyer, and then I will email this out to everyone who has attended today. So today's speakers, we have Sam Chu, who is the chairman of our Singapore chapter. We have Daniel Tay and Hong Mei Ling. So Daniel has been in practice since 2007, specialising in commercial law and the engineering, construction, hospitality, luxury, commercial fit-out and residential design and build sectors, advising on corporate agreements, contract drafting and representing industry and private clients in commercial disputes, engineering, construction, insolvency, regulatory offences, defects, damage, insurance, professional indemnity, adjudication under the Building and Construction Industry Security of Payment Act. Mei Ling is an Associate Director at Arcadis Singapore and a member of the Singapore Institute of Surveyors and Valuers. He is a quantity surveyor by training with more than 10 years of experience in the cost management and contract administration of construction projects in the civil engineering industry. So to begin with today, I'm going to hand over to the General Manager of our Hong Kong office, and she's just going to give an introduction of herself and her role in the office in Hong Kong. So Vivian, would you like to take over?
Yes, thank you. Yes. Dear CAPE members in Singapore, good afternoon. It's Vivian C, General Manager of CABE Hong Kong office. CABE Hong Kong office has been set up early this year with the following aims. First, we support and ensure proper governance and operation of CAPE chapters in the Asia-Pacific region, including monitoring and reporting of the compliance to CAPE standards. Second, we help raise the profile and influence of CAPE in the region with industry and government through representation to local government authorities and other professional bodies locally. Third, our office setup is to provide front of office function for CAPE headquarters in the Asia-Pacific region, including membership recruitment and renewal, facilitating members and chartered engineer interviews locally, liaise with local academic partners, communication to members on behalf of the chapters, disciplinary matters and promotion of benevolence of CAPE. Last but not least, we are committed to delivering quality local activities, including regular committee meetings for each chapter, regular CPD sections to members, annual general meeting for each chapter and conference and other formal events. Our CAPE Hong Kong office is led by Chairman Mr. Kieran C, and you can see his background and accomplishment to the society on the PowerPoint slide. I will support and look after the daily operation of Hong Kong office for CAPE. May we move to the next section and pass to the mic to Sam Chu, Chairman of Cape Singapore chapter, to introduce the speakers this afternoon and share more about the topics. Thank you.
Yes, good afternoon. I'm Sam here. I'm the leading moderator for Singapore chapter. Thank you, CAB UK Hong Kong, for organizing this webinar. And also a big welcome and big thank you from participants from Singapore, Hong Kong, Malaysia, and UK, and spending your valuable time with us on today's hot topic. Yes, next. Yes, now is the most difficult time not only in Singapore, but across the globe. WHO declared COVID-19 for the first time in March 2020. It seems like a third world war because many got infected, and we sympathize those fatal cases recorded. We take this opportunity to acknowledge the hard work of the heroes, from frontline medical professionals, health workers from the healthcare system, the NGOs, the government to government, private entity, social and volunteer workers, and all those who have contributed and contributing now. All this effort is going towards Singapore United spirit by staying engaged as a nation for unity, solidarity, purposefully and positively. Once again, Cape like to extend a big thank you for all contributing now during this difficult period. The agenda today, next, yes, the agenda today, I will have an introduction of myself, Mr. Daniel Tay and Ms. Hong Mei Ling. And the next thing is COVID-19. How is it impacting Singapore in the construction industry? The third item is we have a new act, all right, so-called COVID-19 Temporary Measure Act, April 2020. So this will bring us together, and with the expert, hopefully we will have a key takeaway after this session. Last, as mentioned, there will be a Q&A session, and we move forward. Thank you. Next. At a glance, myself, Sam Chu, Daniel Tay, and Hong Mei Ling. Introduction, Mr. Next. This is a little bit of myself. I am presently as a senior project consultant with a private company performing project construction management as a consultant. Next. I have started stepping into a construction site since 1986. The whole duration I have performed as a contractor as well as a consultant. Through the years of experience, the best practice as a whole is to able to adopt a constructive collaboration connecting the 3 Cs, namely the client, consultant, and contractors. Personally, I have done some projects in Singapore, Indonesia, Malaysia, Thailand, United States, and Bahrain. At the same time, I'm also a trainer, conducting training and assessing to enhance competency in construction-related processes with ICT. Next. Our legal advisor, Mr. Daniel Tay, he's the partner in the Chan Neo law firm. Next. Next, yeah. He has the wrong introduction is Daniel frequently provide legal advice on contract administration related matters to payment, damages, defects issue, and with a strong emphasis on quality work and successful outcome. He's also a regular speaker on building and construction law, and frequently cited in legal issue for news media. The introduction and for Daniel. All right, next. Okay, our contract administrator today, Ms. Hong Mei Ling, as introduced, she's an associate director for Academy Singapore. Next. There's more than 10 years experience in training as a QS. He's a member of the SISV Singapore. He holds an honor degree in housing building and planning from the University Science of Malaysia. Her effort with continual learning never stops. Hence, she continued to have secured a specialist diploma in construction productivity, a BIM level 2, and she specialized in cost management and contract administration. Next. COVID-19, the hot topic. Construction is really badly affected by this virus, so-called COVID-19. We have impacted and a lot of difficulties as well, and prevented many construction-related contractors to fulfill their contract obligation. Our expert will discuss and highlight industrial impact and possible application of legal concepts. Next. Construction contract obligation. What's now for future? A lot of question is being asked in the market today. How do we fulfill construction obligation? Whether it's force majeure, frustration, loss and income claim, to call bond, and all important issues. So for now and for the construction specialists as a whole. Sir John Egan, 1998, with the Rethinking Construction. Looks like we need to further improve with the Rethinking Construction version 2020. Next. Now, in the invite we sent out, we have conducted a survey, a Google form survey. The question is, are you affected by the unprecedented COVID-19 pandemic? 80% replied with a yes, which means to say, yes, majority of us are affected by this COVID-19 pandemic. Next. Next question. How many of your organization's sites are closed? The result came back during this circuit breaker, 75% of the sites are closed, which means to say literally there's no work, there's no activities. We expect a dispute, or we expect things coming in, and it has to be cleared to answer all this question mark. Next. Next. Circuit breaker. Circuit breaker. The previous slide. Okay, we talk about this circuit breaker here. It came out in a national newspaper and saying that construction can gradually commence again from June the 2nd with safeguard. Now, for the benefit of the participants from Hong Kong, Malaysia, now circuit breaker simply means a set of stringent preventive measures set up by the government to literally suspend work in construction site. The first circuit breaker is from 7 April to 4th of May, and subsequently it was extended to 1st of June. So question again is, what is a contract implication? How to fulfill the obligation in the contract ending We have disruption for the last 2 months and coming maybe 3 months. Next. So we have this new act from the Ministry of Law together in collaboration with our BCA, Building and Construction Authority. This new act, so-called the COVID-19 Temporary Measure Act, and now provides some space for those affected by providing relief or deferring obligation to a later date. So the question is when, how, and what need to be done. So we will discuss this key feature of the act and implication in this sharing session to discuss, and we know it's not going to be easy, okay, to sustain and to ride through this headwind, so to speak. A good understanding of the impending matters, particularly the contractual, what we must do so to secure our present and future. Next. So to dig in, we will elaborate a little bit more on this COVID-19 Temporary Measure Act, how we take care of this non-fulfillment, and what measure is fair and reasonable to move forward. Hence, I will hand over this insight to our Mr. Daniel Tay, being the legal advisor. Thank you.
Thank you, Sam. Okay, could we have my slides? Thank you. Hi, everyone. Okay, thanks for spending this afternoon while here in Singapore and Hong Kong. I'm presuming it's the afternoon. In the UK, it's probably the morning for you. So thanks to everyone for tuning in. I cannot promise to be as entertaining as Netflix as you might be watching a lot of now, given the current work slowdown. But I will try my best. So all I do ask is you try to stay awake. We'll get through this. So just a bit of a spoiler alert. Singapore, being Singapore, has what I've done is to there's a lot of government intervention, at least right now, to try to prop up the industry to make sure that well, not everyone goes bust by the time we get to the end of the year. The intention really is that the construction industry stays alive as much as possible. And I'm not sure what's happened in the UK and Hong Kong. I understand that we have quite a few Hong Kong attendees here today. So I suppose the takeaways for the Hong Kong and UK side might be, if there's a way to influence policy or the local authorities on it as a matter of policy, then this is what has been happening in Singapore. It's been ongoing for the past or at least the early part of the year, because this was a legislation that quite literally was just pushed in on just one reading only. So in Parliament, it just came and went in straight away. And I think in this case, the talk really was that it's not about the contracts, it's about what is right, what is just, and how do we help contractors to stay alive for the future. So really, this is an important bread and butter issue for a lot of people. So fair warning, is very Singapore centric, but I do promise that this is something which does apply to the industry. It still relies on the usual contract principles and for construction as well. So I'm just going to go on with this. Next slide, please. So what has happened is that we have this COVID-19 Temporary Provisions Act. So this is a legislation that has been kicked in specifically for the industry. And of course, the regulations for how it's supposed to take place. Next slide. So what we're going to talk about are the key features for the construction industry over here in Singapore. Next slide. So what it does is that it covers a range of contracts under the Act. There's construction contracts, supply contracts, and of course the Act also deals with things like tenancies, but we won't be going to that today. So the Act is divided into a few sections. There's temporary relief provided just for these few months. There's also some restrictions on performance bonds, and we talk about LDs and for contract relief on a temporary and permanent relief as well. And so I will then finish off with how relief is then obtained, and also what is the effect of an assessor's determination. Next slide. So what the contracts are covered, we have construction contracts and supply contracts. So in Singapore, and I think in Hong Kong as well, we have adjudication. So in Singapore is the Building and Construction Security of Payments Act. So this defines what contracts are covered under the Act. We have the usual construction work contracts for supply of goods and services for construction work essentially. We have supply contracts for supply of raw materials to the work sites. Now this was a issue which was highlighted in Parliament as well when the Act was introduced, because quite simply, I think we all saw supply cut off for a lot of people, and work sites just quite simply could not get supply of raw materials. This of course meant that the supply of the materials went had problems. We then want to cover construction work as well, because if the workers can't do work, there's no materials, work sites are going to be down. So bringing in the SOP Act for Singapore, at least, it's a bit of an interesting development as well, because the Act for SOP has just been amended in December 19 to bring in things like prefab contracts, because that's to take into account development in technology. So in Singapore, we actually have prefab plants both based locally and also in Malaysia. So what that means is that even if it is a Malaysia prefab contract and it is affected by the movement control in Malaysia, for instance, then that is a potential class of contract that can be covered under this Act as well. Right. Next slide, please. All right. So the question is, when does relief apply? Now, this is going to be a very key issue, because we're going to have contractors on the site now who have not been working for the past 2 months, I think. So restrictions kicked in about early April. Singapore calls it a circuit breaker because of lockdown in many places elsewhere. Essentially, they started off with a lockdown with only exempted industries in key infrastructure. So in Singapore, by key, it usually means perhaps the deep tunneling for sewerage, for perhaps some of your MRT lines, maybe treatment plants, for instance. So in the first phase of the circuit breaker, these actually had exemptions. But once the dormitory issue blew up, and we then had dormitories for the workers being declared as isolation areas, then exemptions were all pulled pretty much in the second circuit breaker when that was announced. So pretty much that kind of means that for everyone in the construction industry in Singapore, those who can work from home have been working from home. Work sites have been closed. The only work going on has been vector prevention, essentially mosquitoes, and everyone has been waiting to see when work can restart. So how does this relief apply? What it means is that it provides temporary relief for an inability to perform a scheduled contract, essentially construction and supply contracts. It starts in Singapore from 1st of February, because that's when the government said, okay, it's about this time when Singapore started to kick off the COVID-19 issues. And then the question is it affected by a material extent? What is a material extent? So this may differ from contractor to contractor. It's a bit of a question mark. Of course, we hope that this is not the case. I mean, what is a material effect for one contractor may not necessarily be a material effect for someone else. But either way, I do think that universal application at the moment might be the case, because everyone has been shut down at least for the past 1 to 1.5 months, roughly. Right. Okay, so how about other contract issues? What about, say, last slide, go back first. Okay, so what about, say, design issues? What about defects? Are these covered by COVID-19? Well, I would say that if it's an inability to perform a contract in some way for providing services, but this is not due to COVID-19, then it might not be covered. So for instance, if you have a defect and your defect was not because of COVID-19, but because of a workmanship issue, then yes. But if you're going to say that your defects are because it's still there because I can't get someone in to rectify the defect, then maybe, but it's a separate issue because that's a manpower issue. Okay, next slide, please. So what is stopping now is quite a blanket stoppage of everything in terms of disputes, pretty much. So you can't start or stop, you can't start or continue a court case if the COVID-19 is the key issue for the proceedings. You can't start or continue arbitration or court or arbitration. Basically, you can't enforce a judgment, you can't enforce an arbitration award, you can't enforce an adjudication determination, but I would say that the words here are just enforcement. It doesn't actually stop you from carrying on with adjudication, because as it is in Singapore and around the world, cash flow is really the key for the industry. So you don't stop this. It still allows adjudication to go on, because the contract timelines for adjudication back then when they were implemented, it's still pretty much a quick and fast issue. You get in there, you sort out your determination, you get your result. If you want to enforce it, you then have to show that it is not due to COVID-19 that this guy can't pay you. Okay. It also stops things like enforcement of security over your machinery and your plant. So if, for instance, you have a judgment or something like that, but you have a contractor who is not able to carry on with work and he's really just affected by COVID-19, he really does have to show that COVID-19 is affecting him, and that's why you shouldn't be enforcing your right to claim his machinery and plant and sell it off. Insolvency as well, no scheme of arrangements, judicial management, winding up bankruptcy, these are all affected at the moment. I'm going pretty fast at the moment. I will get to the very key issues a bit later. So right now, let's talk first about how long it lasts. So it's right now it's going to be 6 months from 20th of April to 19th of October, but it is a bit retrospective because it covers COVID-19 events all the way from 1st of February. So effectively, it's 1st of February to the 19th of October. And it continues so long as the applicant has not withdrawn it, or an assessor has determined that the earlier prohibitions don't apply. Now, it can also be extended for up to 1 year. So, which means that you get a potential maximum long stop of 19 April 2021. Now, this is a maximum temporary relief period. So we'll see what happens sometime closer to 19th of October when the current relief ends. Now, the important thing to note though is that the notification for relief must be applied for. So that's very important. Otherwise, you basically, it's not an automatic relief that is granted across the board for everybody. So that's why this act is an opt-in act, essentially. Next slide. Okay, let's talk about bond calls. As we all know, bond calls are very serious matters. We know that it's got serious implications because the insurer and the bank pays on an on-demand bond and then claims it from the contractor. If the contractor can't pay, the bank or the insurer then calls on the personal guarantees, which are usually provided by the directors of the company, and that is of course very onerous, and that's something which I think this act really does address. So what it stops is that you can't make a bond call until it is 7 days before the expiry period if the notification has been given. Now, it is not a full prohibition, despite what the Ministry of Law and the BCA circular has said. That's the one that Sam was showing just a bit earlier. So they have this little FAQ, and it says that a call on a bond will be prohibited for 6 months. That's not the case. That's not what the law says. So right now, what it means is that relief is only given if you have given notification. That's one. And 2, the bond calls are stopped until 7 days before the expiry, but you can extend the bond. So that might then just bring you out beyond this 20th of October period as well. So you get relief all the way until 20th of October. And after that, well, we'll talk about after that a bit later. So what if your current bond expiry is after 19th of October? Well, I would say that the same temporary relief applies. Basically, no bond calls until 7 days before expiry. So the relief appears more to protect contractors who have bonds expiring between 1st of February to 19th of October. Now that really does make sense, because as we know in a construction project, you're gonna if your bond is gonna end about this time, it also means that either you have substantial completion about this time, or you might be ending your DLP and you're gonna go to final accounts. So maybe, and this is about the time where everything, I would not use the usual terms, but it does mean that disputes usually arise during this time. And so if the expiry is after the relief period, then the demand cannot be made if, as what I said earlier, number 1, notification for leave must have been given, not withdrawn, and assessor hasn't said that the notice doesn't apply. Now, for those in Singapore, if you're reading section 6, nothing in there says anything about filing for relief, but my reading of it is that it flows from section 5. So what that means is that you could still get hit with a bond call if if you haven't done the notice, or 2, if you have done the notice but your extension is done late. So this is something to be very careful of. Next slide, please. Next slide. Okay, so what it does importantly, this is possibly the most important section for the industry, because it does grant relief potentially on a permanent basis. Now, this is very important for the industry because it is not just a here and now. We saw that all the stoppages earlier were just for your starting and continuing with court or arbitration proceedings. This one actually says that when you have an inability to perform your contract from 1st of February to 19th of October, for this particular period, it is to be disregarded for LD calculation. Your employer can't impose LDs. And 2, it is a defense to a claim for breach of contract for the inability to perform. So this grants relief potentially on a permanent basis for the industry, even after the COVID-19 relief ends. Right, next slide. Okay, so what is not prevented? Now, what it doesn't prevent is any rights or obligations that arise before or after the period that is in the Act. So before means anything before 1st of February doesn't apply. Anything currently that is after 20th of October doesn't apply either. If you have a judgment or arbitral award or an adjudication determination that has already been issued before you have filed the notice, then you don't get the relief. So this makes it important to consider when a notice for relief should then be given. Next slide. So what then is the role of the assessor within this COVID-19 temporary measures relief provisions? So the assessor is only to decide if the inability to perform is due to COVID-19. Now, only for the construction industry, let's leaving aside everyone else, the assessor is not to assess or determine the extent of delay that is attributable to COVID-19 or LDs, and he can't order damages. So he can't order that any amount of money be paid from someone to someone else. Now, this is not in the Act. So if you've been reading the Act, it's not there. It's in regulations. So Okay, next slide. So in a bond call situation, what might a court decide? So we have the bond calls, and then we have the arbitration and other issues. Let's talk about the bond calls first. So number one, has there been a notice for relief that has been given under Section 5? And then what if an application for determination hasn't been made? Is the bond call within the 7-day bond expiry date? And what if the bond call includes contract breach or delay before 1st of February? Okay, now it's really like this. The BCA circular actually states that the substantive merits are decided separately from this assessor process. But this also assumes that the notice for relief remains applicable. So on the one hand, what it means is that while it is not mandatory to apply for an assessor, a party that receives the notice might practically or should have to apply anyway. Because on the one hand, the Act states that the notice stops the call, for example, on the bond, and you can't think of LDs. But BCA then says that it is not mandatory to apply unless the notification clearly should not apply. So now to complicate this issue, the Act also states that an assessor's determination is binding and there is no appeal. So let's then look a bit more as to how the government and BCA have tried to reconcile this issue. Next slide. Now, what the circular says is that the party who has served the notice would still have to demonstrate to the adjudicator, the court or the tribunal, that the delay or breach was in fact caused to a material extent by COVID-19. And the non-defaulting party would also have the opportunity to dispute the defense that's being raised by the applicant. So how do we reconcile this with the Act, which states that the assessor's determination is binding and non-appealable? So it would appear that the construction industry has a special carve-out from the Act because of the complexity of the construction industry in determining LDs and in determining the periods or what events or what is critical path and what is critical analysis. So all these issues are things which the COVID-19 Act specifically does not want to deal with. So while an assessor may have ruled against an employer or an upstream contractor against a subcon, this would appear binding. But what I would say is that the extent of the LDs and the damages that are affected is left to the adjudicator or the arbitrator or the court to decide. So it would be what I would call perhaps a light touch approach, meaning that for the construction industry, it gives you the relief, it gives you a chance that for clear-cut cases, it's very clear, for that you do get the relief. But where you deal with things like LDs and contract breach in the construction project, then your assessor perhaps might just be saying, yes, it applies, and you've got some relief. But if it doesn't say how, it doesn't really leave the contractor with much to relief, practically speaking, because how is a assessor to really help the contractor when the contractor can't get any monies from the employer or the upstream contractor? That is an issue. Next slide, please. So a key question that's come up is that, is there an extension of time that is granted by law? Does the COVID-19 Act give you an automatic extension of time? Well, my answer is that the Act is just a statutory defense to the imposition of LDs. It is a defense to a claim for breach of contract for inability to perform. So let's do the checklist. Defense to LDs, yes. Does it state the words extension of time? No. Is this a deliberate omission of this term? Maybe. Why doesn't the Act say a contractor will be entitled to an extension of time for the affected period? That would be simple, but it doesn't say that. So another clue would also be that as we looked at the assessor's functions earlier, what the regulations and the Act actually say for other contracts is that the assessor has a power to issue a further determination to make someone pay someone else an amount of money, and it could actually be enforced in court as a judgment. Now, this is not the same over here. We don't have, for the construction industry, we don't have a situation where the assessor can actually say, you employer, bad, you have imposed LDs, you contractor, you can get it back from it. No, not the case. So let's look at the next slide. So what is the status then of prolongation claims under the Act? Loss and expense claims. These are, of course, inextricably linked to your EOT and, of course, your contracts. We'll come to that. So the Act, as we see, is silent on extension of time and prolongation. These two terms are never used in the Act. What the Ministry of Law and BCA say is that in the event party is entitled to apply for an EOT under the contract, it should do so, in which case there will be no delay and the COVID-19 Act will not be triggered. So how about force majeure? How about things like your lockdown, your movement control measures, your Singapore dormitory isolation areas where your workers can come out? Now, how about what happens then if you have a EOT contract exclusion for force majeure? Does common law apply? So let's examine what the Act does. It gives you a statutory defense to LDs. It doesn't state EOT. Is it a deliberate omission? To answer the earlier question, looks like it. So why? Because of the objective of the Act. Whatever we do in the industry is that we need to understand the objective. The objective of the Act is to just give you perhaps a light touch solution to not getting hit with LDs, and perhaps some caution in interfering with the contract mechanism. So I would then pose the question, what does the contract say about EOT and force majeure, and what is the language used? Now, and I think the biggest question for all of us is, if you follow what MinLaw and BCA say, and you just apply for an EOT, and well, MinLaw and BCA say that in which case there will be no delay and the COVID-19 Act will not be triggered. So let's say you apply for an EOT and you don't get it. And by then, perhaps if your Act protection has ended and it's now 20th of October and you haven't gotten your EOT, or perhaps the employer hasn't replied to you on your EOT, what happens then? Well, practically speaking, shouldn't you then issue the notice anyway? The answer is probably so. All right, next slide. So what is going to happen now? Now, some questions would be, have you had to serve a notification for relief since the Act was commenced? Now, how effective do you think the Act has been for overcoming LDs and bank charges during these times? Now, what happens on 20th of October? So, at the moment, an assessor determination, once the relief has gone in and the receiving party applies to have it assessed, I think it's going to be a bit of a rough justice situation. It's very similar to adjudication because of the timelines for adjudication, and also because in Singapore, for the notice assessing process, there are no lawyers involved. Lawyers are excluded. So what it means is that the parties handle the situation themselves, maybe with lawyers in the back room, maybe. And then it's potentially very rough and ready, because the regulations say that the hearing can even take place by email unless the assessor decides that a video con by Zoom or something or a physical hearing is needed. So the assessor can even dispense with a hearing and decide based on the forms and documents submitted if these are actually sufficient to decide. So is there actually potential for abuse of the notification system? Maybe. But I would say maybe less so for construction matters, if adjudicators or the court or the arbitrators still have the discretion as recognized by MinLaw and BCA to ultimately decide on the substantive issues of LDs and the extent of the inability to perform. So these are still very much real issues that perhaps also explain why the circular says, is it mandatory? And the answer is no. And this is the answer. So in summary, I think that what happens now really is that for the contractors which are in a bad position caught between COVID-19 and the employer, then you have your worksite stoppages, you have your work that's going to be a bit slowed down. You're going to be facing 2 to 3 months of delay, LDs. And even now, even though the second circuit breaker is lifting on 2nd of June, the additional measures now are really that everyone has to be tested, the workers to be tested, or everyone of that before they can get back. And there has to be the physical distancing measures that to be implemented before work can even take place. So, or even for transport of workers, there's got to be dedicated transport providers, for instance. So from people I speak to, they tell me, you know, all this is not going to be done until at least end of June. So if that's the case, then you're potentially looking at work slowdowns from 1st of February, and you then have knock-on effect from your April stoppages. So April and May, that's 2 months so far. If you're affected from 1st of February, there's another 2 months. So total, you have got 4 months. If next month in June you slow down as well as 5 months, are you going to get hit with LDs for 5 months? It's a very, very real question. And if this knocks on, then everything is delayed, employer suffers, the contractor suffers. And what then is the contractor to do? Well, file the notice if it's applicable, and if for the employer, dispute the notice if that's necessary. And what happens on 20th of October? This is a very real question, because then at that point in time, all the interim reliefs are going to be lifted. And then that's the point at which we also then take stock of what are the permanent reliefs that are still in place at that point in time. So what if there is an assessor determination that is already in play? Well, all these determinations can also be taken into account in any court or arbitration or adjudication proceeding that are still pending. As to the effect and the extent to which this will really affect the adjudicator, the court, and the arbitrator, that is still a question that, well, for which the Act still gives them some discretion to determine it. As we know, we are still going to have experts in to talk about your delay issues. You're still going to have your QS experts in to talk about your valuation issues. You put all those two together, put it together with counsel and the arbitrator, and then I think hopefully we then still get a fair outcome, taking into account the potential for COVID-19 relief that is valid or applicable to the contractor. So thank you very much. Mailing, I think we'll be talking a bit more about the contract provisions for force majeure, and also for the various form contracts that are used for the contractors. So I will leave mailing, and I'll hand it back to the organizers. Thank you.
Thank you, Daniel. I'm just going to unmute Mei Ling, and then she can take you through her presentation. Hi, Mei Ling.
Thank you, Jordan. Yeah, thank you, Jordan, and thank you, Dania. A very good afternoon to all. Thanks, Dania, for your informative presentation on the COVID-19 Temporary Measure Act. Yes, we noted the point that the Act keeps silent on the EOT claim and the prolongation claim, as the Temporary Measure Act is defense mechanism for the contractors in response to the pandemic. Therefore, we need to fall back to the individual contract. So let me continue with my presentation to touch on the standard form of contract in Singapore. Next. Okay, we will briefly run through the content. What are the typical standard form of contracts adopted in Singapore construction industry? Then we zoom into the key aspect in relation to COVID-19 in terms of the EOT and claims provision. And then we summarize it with factoring in the new risk as a result of COVID into the future contracts. Next. Next. Okay, in Singapore, typically we adopt 3 different standard forms. In general, the public sector standard condition of contract for construction work, in short PSS-COC, is generally used among the public sectors, whereas the REDAS design and build for main contract and SIA building form of contracts are generally used for the private sector. Next. Next. We move on to the EOT provision in the standard contract that we have introduced earlier. This is an overview of the contractual provision in the standard form. Each standard form has defined a list of relevant events allowable for the contractor to claim for EOT under specific clauses. And it is a condition precedent for them to submit a notice prior to make that claim. So for the purpose of the presentation today, next, I will only highlight the relevant clauses that the contractor usually use to claim for EOT under each standard form of contract. Next. Under the PSS-COC, in clause 14.2, grounds for EOT, the relevant clauses that I can highlight from this list, which contractor can usually use to as a ground to claim for EOT under this COVID-19 event. They usually take or use the ground as a force majeure or lockout causing the delay is in Singapore, or compliance with any requirement of law, regulation by law or public authority or public service company as stipulated in clause 7.1. But this clause 7.1 deals with notices relating to the work itself only. But the work has not been modified due to COVID. In my view, this is not really a relevant clause that contractor that can use. Clause 14.2K, subject to clause 13.1 and instruction by the superintending officer to suspend any work. Okay, we know that during these 2 months, the government has issued a circuit breaker, in short CB, to stop work for all the construction projects. So whether the contractor can use this clause to claim based on this, we have to think and consider whether it's valid or not. Next. Under the REDAS form, clause 16.1 lists down the grounds for EOT claim. And one of the event listed is the force majeure. In the previous PSS-COC form, the force majeure is not defined. But in REDAS, the force majeure event is defined under clause 18.2, which is listed here. As you can see, it's nothing to do with pandemic or this epidemic or outbreak of disease. The number of items listed under this force majeure is only confined to these 5 items. The last item on the 18.24, industrial action by workmen, strikes, lockout or embargo affecting directly the work, is still open up for interpretation, whether it's valid or not to be used as a ground to claim. There's another clause, 16.1.5 on suspension of work pursuant to clause 31.11, but this is due to non-payment by employer. So it also has nothing to do with the COVID-19 pandemic act. Next. Okay, under the SIA standard form of contract, clause 23 bracket 2, the list of ground of EOT, one of the few items that are being mentioned are force majeure. But under this standard form, force majeure again is not defined. Similarly to the previous two, there are if you have a lockup or embargo, whether domestic or foreign, this one is also open for interpretation. Next. In the SIA standard ground, there are two more clauses related to shortage of labor and material. Why I put an asterisk? Because in the standard form, these two are subject to suit individual contracts. To date, I think in my experience, I have never encountered contracts that adopted these two clauses. So if your contract has these two clauses in your contract, then it may also open up to interpretation whether EOT can be claimable or not under the shortage of goods and materials or labor arising out of this COVID-19. And the last event that I think which is relevant is the valid suspension of work under clause 33.4. Okay, we go to the next slide. So the common question are being asked arising out of this pandemic is outbreak of disease, epidemic, or pandemic is defined as force majeure event. Under the RADAS, we have a list of specific defined event for force majeure, but RADAS and SIA did not really define this event as force majeure. But our view is outbreak of disease or epidemic, pandemic are not defined as events of force majeure, neither do the fact fall within the relevant events under most of the construction contract, entitling the contractor to EOT. But of course, this is based on the standard form of contract. The contracting party needs to do a check on their contract particular condition to confirm that there are no relevant amendment to the standard form of condition of contract, whether under PSSCOC, RADAS, or SIA. Okay, next. Another popular question are being asked, should EOT claims be rejected? I mean, from the perspective of consultant for evaluation of the EOT and client's view, based on the contract, COVID-19 pandemic has undoubtedly affected contractor, resulted in delays. From the outset, BCA earlier email circular dated 1st February 2020 that the work progress has been delayed due to the impact of the Wuhan coronavirus in China. So this invite the public to submit EOT claims, and the public sector now are considering this EOT claim as an ex gratia basis, of course subject to substantiation and mitigation and notification submitted. This was before the COVID-19 pandemic was even officially named as such before the CB measure. Next. Okay, next we will go into claim provision in the standard contracts. Next. Similar to the EOT provision in the standard form, there are also a list of relevant events stated in the standard form that allows contractor to claim, providing they fulfill the condition listed in the individual contracts. In our context is claims due to prolongation. Okay, next. Let us go into the standard form. In PSS COC, L&E is defined as a direct relevant cost of labor, plant, material, or goods actually incurred, and cost of an overhead nature actually necessary incurred on site. Next. Then the list of events that are arising that allow contractor to claim for loss and expense that we highlight here is one of the reason that contractor can might use it, which is the suspension by the SO of any work. In this case, the suspension due to the CB, which might entitle the contractor to consider for to recover for this loss and expense. But this is contractor's view. Next. In REDAS, there's no express provision of claim for L&E defined, but if contractor wish to make any claim for additional payment, they have to give a written notice of their intention. Next. In SIA, similar also, there's no express provision of claim for L&E is in SIA form. Next. Okay, a point to note, in order to make a claim based on the contract, it is very important to note that the claim must originate from particular clauses in the contract. As we have gone through the earlier slide, so far there's no proper ground for contractor to claim out of this COVID-19. Okay. Okay, it must be noted that a grant or refusal of EOT does not necessarily entitle the contractor to claim for L&E. It is also not a condition precedent or vice versa. Taking the PSS COC as an example, next slide. If you see this table, the list of events that allow for claim of time doesn't necessarily give you an entitlement to claim for a cost claim and vice versa. Next. Okay. So the question are being asked due to this COVID-19 event, are contractor entitled for L&E claim? From the previous presentation slide, there is no obvious L&E. I mean, there is no L&E payable event. I mean, ground for them to claim. But do check on the contract particular condition, because L&E claims due to COVID-19 do not arise out of the breach of fault of the employer in carrying out its contractual obligation. Also, assuming there are no acceleration issue involved, if the client were to reject all the EOT and insist of completion per earlier contract completion timeline, without giving due regard to the effect of COVID-19 event, yeah. So unless there are specific contractual provision permitting recovery of such L&E, in general, the employer is not liable to compensate the contractor for the loss and damages. And moreover, the new act also do not give the contractor any monetary entitlement, whether for L&E, prolongation costs, or anything else. So what other option that contractor can pursue? Okay, next. We can look at ex gratia claim consideration. Ex gratia claim consideration means this claim has no legal entitlement. We sometimes call it sympathetic claim. This usually happen when, as a last resort, when contractor has suffered a significant loss through no fault of the employer. A common event happened back in 2007 is the sharp surge of price of sand on the export ban by Indonesia. So this caught many by surprise, and as a result of that, after a series of negotiation and all that, I think contractor and employer come into an agreement on to accept an ex gratia cost sharing regime with contractor to alleviate the burden. So similar approach might be adopted by the government together with the industrial fellow practitioner to consider this all the claim arising out of COVID-19 as part of the ex gratia consideration. Next, because we acknowledge that the due to this circuit breaker stop work, but at the same time contractor is incurring costs on running the maintaining the site and paying for their staff and worker, maintaining the machinery and equipment, which need to be considered as well. Okay, next. So okay, coming towards the last few slides of my presentation. So with what's happening in the industry right now with the new COVID-19, with this unprecedented event of this COVID-19, how can we factor this new risk into the contract? Next, these are some considerations that we highlighted, which we can consider in forming the new contract in future. To lessen the risk pricing by contractor, we can consider to include the fluctuation clauses for specified materials to be included in all future contracts, or contracts to factor in business continuity plan to anticipate any new or repeated CB measure, or company to consider reviewing frequency of the payment to supplier to ease cash flow. Yep. That's the end of my presentation. Next. Yeah, for more information or insight of this post-COVID-19 landscape for Singapore construction, you may access it by scanning the QR code or accessing the link on this page to have more insights on the issues related to COVID-19 issue. And I shall end my presentation. I hope that my presentation and the material that I have shared serve as a useful resources for you to mitigate the impact of COVID-19 on your businesses, project, and people. Thank you. I shall hand back the presentation to Jordan, the organizer.
Thank you, Mei Ling. So that about brings us to the end of today's presentation. So I've had a look, we don't actually have many questions. No one has really sent any through. So it may be that people need a little bit more time to submit the questions. So you can send them through to me outside of the session, and then I can have a call or an email conversation with the speakers from today and put together a little flyer with the questions and the answers. So I will just unmute all of the speakers from today and just have a little chat.
Hi, thanks, Jordan. I actually see that there's been a few questions on the checklist on the little panel on the right. So
yeah, you can go through and answer them if you want. It's up to you. I just didn't know, there's not many, so it's up to you.
Can do. Thank you. Okay, I'm gonna have a go at the first question. That's from I won't read out the name. The first question is that it's regarding an operations and maintenance contract. And there's some manpower disruption issues due to COVID-19, and the provision of manpower is disrupted. And then the agency didn't pay the full amount and has prorated it based on the manpower provision. And the question posed is this fair? Well, I'm just going to look at it first in one way. The first one is under the law, this COVID-19 Act. Does the Act apply? So the first question for this is, if we look at the Act and what contracts it covers, it talks mostly about things like loans, banking loans, bonds, hire purchase agreements. It might be event contracts because we had all sorts of weddings in Singapore that were disrupted back then, tourism, construction, supply, or leases and tenancies. So what we have here sounds like a FM contract for operations maintenance. So unless you are saying that your contract perhaps is in relation to supporting DLP or something like that as part of an ongoing construction project, then potentially we might not actually have coverage under COVID-19. However, what I would say is to the question, is this fair, is that perhaps that is a question for the contract itself. And if the contract is silent on things like force majeure and what mailing has touched upon, which are applicable for the usual construction contracts, then a big question really is going back to common law, meaning what are the common law principles has developed by the court in Singapore as to how to deal with such potential issues. So I think that's as far as I can go in terms of advice, because my insurer wouldn't be happy if I were to give advice on such a forum, so not a good idea. But thank you very much for the question. But I do hope that you're able to consult with someone to obtain some advice on this. Okay, there's some other question. Bilok has asked. Bilok is also part of CABE. Bilok, do you want to just elaborate a bit on what you mean by your question? You have asked about the actual notification date for contractor to submit. What do you mean?
Yeah, I'm talking about actually when the contractor can make a date. What's the latest date, earliest date for notification to the employer?
Okay. Well, I think the quick and fast answer to that is before anything happens.
Because it's already 2 months over. No? If they not submit now, is it too late?
Well, it's like this. The Act gives a retrospective effect, which means that you get protection starting from 1st of February all the way until currently 20th of October if your COVID-19 event affects your project site. So it gives you retrospective protection because if you have filed a notice, then it protects you. If, however, in the meantime, before you go file your notice, you get hit with bond call, that's one, you would still get hit. You can't get out of it. And two, if you have adjudication determination that is out already, then it is too late as well. If you have an arbitral award or a court judgment that is against you, that's already out somehow during this very short period of time, then relief is out as well. So back again to the earlier answer would be, file as soon as you can if you think that it's applicable to you.
Thank you. Thank you, Daniel.
No problem. Hi, John. Good to see you here. John, sorry, Jordan, are the participants unmuted?
Only below and Mei Ling.
Okay. Oh, I'm sorry. Okay. We had an earlier question from John Leong, who I see has left. The question that he has asked, which I think is quite relevant, is also when applying the contract clauses, please also consider common sense. And does this mean that the contracting party shall foresee or needs to foresee the outbreak of disease pandemics and make necessary provisions? Mei Ling, this is perhaps a bit of a contractual issue for drafting and preparation of contracts. Do you want to have a go at this first?
Okay. In the okay, prior to this CB, nobody can foresee this pandemic arising in Singapore context. So the contract in Singapore has been drafted without taking this into consideration. So when this happened, and when we review the contract standard form of contract, or even into the individual projects contract, there is no ground for contractors to claim for EOT based on the provision of pandemic, as pandemic is not being defined as one of the item in force majeure. So moving forward, with knowing this as a risk posed in the construction industry, we might consider looking how to draft to include the risk of the pandemic into the future contracts.
Okay.
Would you want to add on, Daniel?
Yeah, so, well, what the Act does is that it only applies to contracts that are entered into, I think there's a stop date of, I think it's 25th March or something like that. So what that means is that contracts which are entered into knowing full well that there's a pandemic going on, those contracts are actually excluded from relief under the Act, because the law assumes that whoever enters into a contract during this time knows full well what he's getting into. Well, that of course may not always be the case, but at least there is an opportunity to address this in the contracts. So Giorgio has a question, why the contracts weren't updated for the force majeure clauses after the earlier medical outbreaks like SARS and H1, well, the earlier medical outbreaks. So I will look at it this in two ways. Number one is that, does your force majeure clause allow for medical outbreaks? That's one. And number two is, does your force majeure clause actually allow you to make a claim for force majeure under something else? Because what we see very commonly in your form contracts is that it would take into account things like your lockdowns, embargoes, or essentially is government control orders or something like that. So while potentially you might not get your pandemics under whether it's medical outbreak or something like that, on the one hand, I would say maybe that might be the case after this, if your drafters of contracts think about putting this in. And you know, actually we looked at when this last happened, I think that was SARS. That was actually 10 years ago. So we're actually 10 years on where this has happened. So maybe does this mean that in the next 10 years time, in 10 years time, we might have a zombie epidemic, and that's the next one that's coming? I don't know. Well, I would say that at the moment where we are really is that if your medical outbreaks are not covered, look for something else and see if that covers you.
Good.
Sam, anything to add?
Yes. For example, right now, with the new measure, they call the SMM, Safe Management Measure. where they are detecting a new way of handling a contract, the activities on site, like how you should manage the workers' accommodation, how you should take care of the logistic issue. So these are additional tasks that may have, I'm sure it's going to add cost to the construction, especially those existing contracts. So long story short, can we regard this as a variation? Because they're changing the way of how things should happen on existing contract.
Well, okay, let me answer this by saying, let's look at the contracts first. Under the contract mechanism, I do see quite a few SOP claims where EOT and change in working or additional cost or additional difficulty is bundled in as a VO claim. So for such claims, especially now, is this considered a VO? Well, for that, I think the contracts are usually quite specific on what a VO really is. It is a change to the design, or perhaps in a different BQ item which the employer has instructed. So that is when you get your AIs or your employer's instruction to actually change a certain thing. So where you have your additional ways of work, additional costs of labor, additional costs of your, especially for next month, additional cost of testing where government is going to bear half, and of course your additional transport costs and everything else. Are these all additional prelim costs that can be claimed? I think Mei Ling and I would probably on this issue say maybe not. But again, that's just as a thought. And I would say that these pretty much all come under damages claims potentially. Can you show that the contract allows you to claim all these as L&E or prolongation, or for some sort of change of scope or the contract? I think it's going to be quite difficult. Mei Ling?
Yes, I agree with your view, because whatever claim that contractor is putting up, you have to fall back on the contractual clauses, whether the contractor allow the contract to claim for the item that they wanted to claim. In this instance, the preliminary cost, but this preliminary cost is not due to employer's requirement, nor due to employer's breach of contract. So I still feel that there is no ground for contractor, there's no ground for the consultant to evaluate this claim under variation. And what the client or employer can consider out of goodwill is based on the ex gratia consideration.
Yeah. Okay.
Yes, thank you.
Sam, you going to close off with anything?
Nope, I think that's good for the time being. Jordan, is Jordan back?
Yeah, I'm here. Are we finished with the questions?
Well, yeah, I think pretty much so. I think we've pretty much gone through the issues which the industry can potentially be expecting the next, well, many months for the future, and what we can expect currently. So it's been great having everyone. Thanks as well, Jordan.
Okay, not a problem. So I will just wrap up then. So I just want to thank both Daniel and Mei Ling and everyone who joined us today. Obviously, it's the first international webinar that we've held, and I think we'll all agree that it has actually gone really well today. So I just want to thank Vivian as well, and Sam and his committee for sourcing the webinar for everyone. If you have any ideas of future topics, please do send them through and we can see what we can get put together. Any further questions or comments, send them over to me. If you think that you could offer one as well, please do let me know. But again, thank you all for joining us. I hope it's been informative for you, and hopefully I will see you all online the next time we host a webinar.